Thank you for joining Quick Tips for Nonprofits. Today's Quick Tip covers the basics for a strong board. Community Law Center is a legal services provider for nonprofit organizations and community organizations throughout Maryland. We are here as a resource and partner for nonprofits, and we offer a variety of legal assistance on formation, necessary filings, and governance for boards, and many other issues involving property, zoning, contracts, employment, nuisance issues, liquor board matters, intellectual property, and more. Today's quick tip is just for informational purposes and should not be construed as legal advice, which really should be tailored to your organization. If you wish to become a client of Community Law Center, your organization can submit a simple application. First, let's look at some of the legal requirements for boards of nonprofits. It's important to understand that nonprofits must abide by certain requirements that are imposed on tax-exempt organizations, and nonprofits must uphold the public trust in their charitable purpose. To help ensure that, nonprofit corporations must be governed by a body rather than one individual. This is why you will never see an owner of a nonprofit. And to further prevent undue control by one person, a majority of the board is required to be unrelated to one another by family or business relationships. So for example, if two sisters want to be on a nonprofit board together, there must be at least 3 other individuals on the board who are not related to them in any way, including a relationship through joint business ownership. By law, all directors owe fiduciary duties to their corporation while they serve on that board. There is a duty of loyalty, duty of care, duty of confidentiality, and duty of obedience. And we will not get into each of these in detail here, but basically these duties mean that directors must always act in the best interest of their organization and with reasonable care, staying informed and ensuring that all requirements are being met. It's important that board members, even of small organizations who are volunteering their time, understand the importance of their roles. Not being aware of something is rarely an excuse, as it is the board's duty to be aware and exercise reasonable care. So in light of these duties, every board should have a conflict of interest policy that each person understands and abides by. Every board should have financial controls in place that each person understands and abides by. And this includes proper financial record keeping, reporting, and accountability, so that, for example, in no situation should only one person have control of the finances. Every board member should understand the nonprofit's mission and purposes, and each person needs to know which activities are allowed and which are prohibited for your tax-exempt organization. Every board member should be familiar with how the organization is supposed to run, including what is in the bylaws, such as for elections, proper notice giving, and other procedural matters. And every board should know and follow all of their filing requirements, both with the state and with the IRS. Now, if you're just starting out and this seems overwhelming, please remember that we are here to help. We regularly help organizations to get familiar with requirements, filings, and governance issues. We offer trainings and workshops and other such resources. Another requirement to note is that in Maryland, every corporation must have a president, a secretary, and a treasurer. These 3 officers' roles must be clearly understood to ensure that the proper record keeping, meeting minutes, reporting, and financial accountability that we discussed is happening. For example, the secretary would probably be the one keeping meeting minutes, and then that person would send it to the board for approval. And the treasurer would probably be one of the signatories on the bank account. As you can see from these legal requirements for boards, you will want board members who are committed to putting in the work during their term. They must avoid any self-dealing, and they must disclose any potential conflicts of interest as they arise. Board members also play very significant roles beyond fulfilling legal duties, as they are the organization's primary advocates. They're working to raise funds, and they do shape the organization's culture and direction. We recommend that boards be composed of persons of diverse skills and backgrounds. The composition of your board should also adequately reflect the composition of your membership if your organization has a membership. For example, the board of a community association should represent the neighborhood's range of racial, age, and other makeup. We encounter many nonprofits with a strong vision and great ideas, but we can't stress enough how important it is to start well with a strong board to ensure that the organization is able to work towards its mission effectively. Or even if your organization has been in operation for a while, it is important to strengthen your board in these ways that we talked about. Thank you for checking out this quick tip. Please visit our website, communitylaw.org, to see our workshops, more quick tips, and some helpful publications for nonprofits. You can also sign up to speak with an attorney for free, up to 45 minutes, or if you're ready for legal assistance, your organization can download our application for services to become a client. Thank you. Take care.